Good morning. Today is March 28th, 2024, and welcome to the New Possibilities Hour, part of the Will Work for Food project founded by Natalie Armstrong Motan in 2020. Every Thursday, Jean Lawler and I host another cutting-edge webinar for mediators, arbitrators, lawyers, and everybody who negotiates. Jean is absent today, but don't worry, she'll be back in flying colors next week. As everyone knows, there's no charge for these great webinars. We ask you to contribute to a food bank if you like what you see. And our audiences have been so generous in contributing in honor of our great speakers. One of my favorite parts of the webinar each week is when we announce the running total of just how much our generous audiences have contributed to food banks worldwide since our programs began in 2020. Natalie Armstrong Motan, would you please do the honors?
Well, hi, Jeff. Thanks so much for the great intro to Will Work for Food. You always do such a lovely job for us. Jeff, our total today is $540,981.62 that people have told us about. Thank you all so much for your generosity. Your food banks and your neighbors really appreciate it.
That is fantastic. Thank you all so much. And now on with today's program, preventing disputes, not just resolving them. And we have a wonderful speaker today, Joan Stearns Johnsen. She teaches negotiation, mediation, and arbitration at the University of Florida, Levin College of Law, where she is also the director of the law school's Institute for Dispute Resolution. In addition to her teaching, Joan has over 30 years' experience as a practicing arbitrator and mediator. She's on the arbitration and mediation panels of the American Arbitration Association, FINRA, CPR, the National Futures Association, the New York Supreme Court Commercial Division, NAM, the American Health Law Association, and Resolute Systems. Joan is also past chair of the ABA section of dispute resolution. She's on the Council of CPR, Senior Vice Chair of the Mediation Committee of the International Bar Association, and a board member of the Miami International Arbitration Society. Joan is the 2022 recipient of the International Institute for Conflict Prevention and Resolution James P. Groton Award for Outstanding Leadership in Dispute Prevention. Who better qualified to talk to us about preventing disputes, not just resolving them? Joan Stearns Johnsen, please tell us a little bit about the food bank to which you would like people to contribute if they are able, and then on with the presentation. The floor is yours.
Thank you so much, Jeff. Thanks to you and thanks to Natalie for inviting me to speak today. What wonderful, amazing work you have done over the years. Just fabulous. So I have selected Food for Kids. There's a local chapter. It's primarily handled by volunteers. So your money will go to helping put food on the table for kids and for them at school. So thank you so much for this opportunity. And I'm excited to speak about preventing disputes, not just resolving disputes. And so I'm going to talk first about a problem that I think everyone on this call will be familiar with and how we can use prevention to address this problem. And then I'm going to bring you up to date on what's happening on prevention. And in terms of questions, I love to address questions. So I'm going to open my chat and invite you to post your questions to the chat. I may, depending on the question, hold off until the end to address your questions, but I really love questions. And if I don't get to your questions during this presentation, everyone can find me through the University of Florida's website or JSJ-ADR. Please reach out. Love to have a conversation, love to continue this discussion. So getting to prevention, well, let's first identify what the problem is. Does anyone not think we have too much litigation? So many of us are probably dispute resolution professionals, and we know that our work goes a long way towards resolving disputes and The statistics, the most current I've heard, the older one was 1.8% of all cases filed in the federal court system make their way through to appeal. Most of them, the rest are resolved with some form dispute resolution. I'm told in Florida that the percentage might be 0.04 cases make it all the way through. So dispute resolution is fabulous. We are resolving a lot of disputes. It's been incredibly successful. But the key there is we are resolving disputes. The disputes just keep on coming. So we still have all of the cases being filed. They're not going the whole way through the court system. In 2022, the Association for Corporate Counsel sent out a survey to their membership, and they got 202 responses from in-house counsel. So these statistics relate to that. These statistics are somewhat imperfect because they have to be self-reporting. There's not a really good place to know with 100% certainty, but of those reporting, about a third reported that their litigation dockets were increasing. And about half said that matter times were increasing. And over half said most litigation matters cost $100,000. So this continues to be a problem. Even if we can get those cases, so we have work as mediators going forward, but it's still a problem of getting rid of all of this or trying to reduce litigation. And so what I'm speaking about today is litigation B2B, business to business, in the corporate area. How do we not only resolve those disputes, but how do we prevent them? So I'm going to start with a little hypothetical to help illustrate what I want to talk about. So let's pretend that we have one corporation that's the Ablex Corporation. Ablex, let's pretend they're the blue buildings, and they're the better funded. They have more financial resources, more personnel, a better distribution system. They're a pharmaceutical company. They enter into a joint venture with Zendox Corporation. Zendox has fewer resources, but they're very aggressive. They are an agile, very innovative corporation with a R&D department that's quite advanced. So Ablex takes their resources and get together with Zendox because there's a new disease that's arrived in the world, and all of these pharmaceutical companies are racing to be the first one to market with a drug to address this new disease. So this seems like a perfect joint venture. Both companies will profit. This serves the world, this serves the companies. What a great joint venture. So one day, the CEO of Ablex just picks up his phone, and it happens to be a New York Times reporter that he happens to know. And he has a 10 to 15-minute conversation with this New York Times reporter who's curious about the progress of the joint venture. So he shares a little bit about the joint venture. He mentions Zendox, and he's very excited about it. And they talk for 10, 15 minutes. He thinks nothing of it, hangs up the phone. The next week, an article appears in the New York Times about the joint venture. He immediately, this is so the CEO of Zendox, first time she hears about this New York Times article is when she picks up the paper and she sees the name of her company in the paper with Ablex, and she is livid. So she calls the CEO of Ablex and is furious. She said, we had an understanding that any marketing was going to be done jointly, that we would decide when it would happen. You never told me. You didn't tell me before. You didn't tell me after you were talking to the New York Times. I think your article leaves breadcrumbs for our competitors. Why are you helping them? This is outrageous. The reaction of the Ablex Corp CEO is she's hysterical. She's overreacting. This is ridiculous. There's nothing in there. They have a conversation ends. Okay, there's no dispute. Nobody's filing a lawsuit at this point. but is there any damage to the relationship? Is there mistrust? Is there miscommunication that's going on? So although there may not be a dispute at this point, is it possible that down the road, when the other problems arise, that this erosion of trust could be an impediment to helping them go through some other problems, right? Could there be attribution of bad motives because of this occurrence or maybe some other occurrences? So I'm giving you an example of CEO to CEO, but it could happen in any other business person to business person interaction. So those of us on this webinar who do dispute resolution know that the cases we get come from the same sorts of things give rise to these disputes that we resolve. There could be some change in circumstances. There's a lot of litigation that came. Who knew there was going to be a pandemic, for example? A mistake could be made. People are human. The wrong widgets get sent. They get sent late, whatever. Sometimes in a joint venture, and this isn't limited to joint ventures, but in a joint venture, there could be a missed milestone. Whose fault is it? Could there be litigation over that? So these sorts of things are exacerbated when the parties are miscommunicating, misunderstanding, when they don't have a strong relationship, and when there's mistrust. Again, this attribution of bad motive that may or may not be there. So when these things devolve and they're not able to get through these problems, that's when you get all this litigation. And the consequences of the litigation, as we saw with litigation dockets increasing, it's pretty significant. This, in our hypothetical, this was a really wonderful business opportunity. If milestones are missed and this does devolve into litigation, this was a good joint venture that could have profited both companies and society that's going to fail for a reason having nothing to do with the reason they got together in the first place. We know it's going to be expensive. It's disruptive. There's unpredictability, as there's risk on both sides. Who's going to win? How much will it cost? Reputational damage, and it's a distraction. These two pharmaceutical business companies are in the business of developing drugs, not litigation. So that's our problem. How do we deal with it? Well, you can hear me talking about the importance of this relationship. Yes, we know that when companies maybe enter into a joint venture, when they have vendors, suppliers, corporate customers, maybe they'll occasionally go out for dinner, they'll maybe talk about one another's families from time to time. But are they really working on, even if they establish a relationship, how much effort with intentionality is put into preserving the relationship, maintaining the relationship, maintaining that level of communication so that they can navigate through these inevitable conflicts and prevent that litigation. So the purpose of this concept of prevention is recognizing that a business relationship is a relationship. How many of you have done a mediation or an arbitration where two buildings walk in the door and sit in the room with you? It doesn't happen. It's individuals. It's individuals who come with all of their cultural values and beliefs, their own negotiation styles, everything we bring, all of our baggage, all of our biases, all of our preconceived cognitive biases come with us. So if we can recognize these people are individuals and work on this, maintaining this relationship, things that are taken for granted, and dealing with this erosion, this potential erosion of trust throughout the lifetime of a joint venture. How might that help us help these parties navigate through these difficult periods? Now, I'm talking about joint ventures. Again, this is a corporate relationship. It could be a distributor, a wine company, manufactures bottles in France, Natalie, and is sending them to the United States. And they can have miscommunication and cultural conflicts as well. It could be any kind of relationship. But these relationships are not designed to last. They're not one-off. They can last for years. They can last for decades. In fact, pharmaceutical companies often have more than one joint venture with the same company at a time. They may have several. Our Ablex and Zendox may have a number of joint ventures happening at the same time, which makes this this problem with the relationship even more severe. If the one joint venture breaks, what does that mean for all of the other joint ventures that they have going on? So initially, we need to recognize the importance of this business relationship and that it really and truly is person to person, like a marriage, right? And these sorts of things are important. Okay, so how does prevention work? What does it look like? What do we do if we want this? If we say, gee, this sounds great, what do we do? Well, there are various approaches, and the beauty of dispute resolution, as we know, can be used. It's malleable, a word I love, bespoke. It's bespoke. You can design what you need for the situation. So in the pharmaceutical industry, in an attempt to address this issue, they have designated people with the title of affiliation manager. So we would have an affiliation manager for Ablex. We could have another affiliation manager for Zendox. And these individuals would have a responsibility for communicating with one another and have hopefully a heightened sense of skill. That's one way of doing it. But again, keep in mind, the joint venture may last decades and people change positions. So you'd have to deal with that. You could also establish protocols for clients or vendors. How do they raise their grievances? Where do they go? What is the process? So CPR, for example, has developed contract provisions, model contract provisions that set forth protocols. You could set up weekly meetings. You could just designate who's at the meetings. You could designate departments for raising grievances. If you have investor state relationships, business ventures, maybe within the government, there are departments to go to raise grievances so people know how to handle these sorts of things. So you can design systems, and at Intel, they have developed a standing or standby neutral program, which has been in effect since 2016. And a moment about the Intel program, and a shout out to Howard Karsman. Yay, Howard Karsman, who started the program in 2016. He retired in 2021, and at the time he left, he has said that Intel did 18 billion with a B dollars in construction over the years from 2016 to 2021. And if anyone out there does construction law, you know those guys have a lot of disputes. Well, in the years that he managed the program with 18 billion in construction, there was one lawsuit that was about $1 million in value. And they instituted a standing neutral program where they They imposed it on their subs and the companies working with them. So these are external systems that can be developed and can be devised based on the nature of the relationship. I'm going to get into what a standing and standby neutral is in a moment, but let me talk about, in addition to systems, right? Well, let me tell you what a standing and standby neutral is let me just tell you right now. Standing or standby neutral is a neutral. So there would be a roster of neutrals or a designated neutral who could be brought in the case of some sort of disagreement or friction, as I've described it, who would then be brought in to help facilitate the dispute. We're going to talk about dispute review boards. I'm speaking about facilitating an interest-based resolution as opposed to adjudicating, although obviously it could be adjudicative, right? So it's more mediator than arbitrator. And they can either be in there on a regular basis, attending meetings, up to speed, or be brought in on an as-needed basis, okay? And compensated by both sides, one side, whatever the program is. All of these systems, again, are bespoke, developed for the particular relationship and the particular potential problems. Okay, so in addition to these systems, again, I'm talking to neutrals, I believe, and we believe deeply in the importance of our skill set. Our skill set that is referred to as soft and essential skill set. So this heightened understanding of things that people take for granted, and we know just how difficult it is. So having either training in-house business personnel in these skills of negotiation, communication, cultural competence, right? All of these skills, either training or using a neutral. So this could be another area of work for all of those with the mediation skill set, to not only resolve disputes, but to prevent disputes. And happily, and Ellen Waldman, this is for you, because this is a point she continues to make that I could not agree with more. In our mediations, oftentimes we are not called upon to do everything we are capable of doing. This clearly would be an opportunity for those with a heightened set of skills, as opposed to litigation experience and knowledge. This is the skill set. So with this skill set, this ability to actually hear not only what's being said, but what's intended, to diffuse tensions, to help preserve trust, to go through all of those things that we do in, taking us back to getting to yes, right? Managing the people, focusing on interests, not positions. Those interests giving rise to interest-based, not only rules-based solutions. We might wind up with interest-based solutions. Let's go back to our hypothetical of the two corporations. So let's say they did decide to sue, right? They decide they're furious and they do want to sue over a breach of the agreement with regard to the marketing and disclosure of proprietary trade secrets, and there's a lawsuit that's filed. How do you resolve that lawsuit? The only opportunity, the only thing the courts are going to do is they're going to look at the law, they're going to examine the contract, they're going to see what the legal rights of each side are, how spelled out are the rules about marketing, are they in there at all, how are the damages calculated in this sort of a situation. That's bargaining in the shadow of the law. Credit to Bob Manukin. That's a legal rules-based result. That's what litigation gives you. But when your objective in mediation is preserving the relationship, and when you're communicating with one another and getting to interests, you can then devise an interest-based solution. Maybe our two companies, instead of litigating for money damages, come up with a new protocol about, they share the fact, I was upset, I don't want to go, how do you want to go forward? Let's make phone calls, bring me on the call in the future, hang up with the reporter, call me, let's do it together. At least if some exchange takes place, give me notice. They can devise how they're going to go forward in a way that focuses on their interests and doesn't disrupt the deal. Sound familiar? Okay, it sounds like mediation. It is not mediation. How is it not mediation? These are mediation skills. These are negotiation skills, separating people from the problem, interests, not positions, sure. But it's a different objective. It's a different application. So in mediation, again, we are resolving disputes. We're already in trouble. My pharmaceutical company is about to file, has filed, has identified it internally as a dispute. The hypothetical I gave you, when they both hang up the phone, who knows if it occurred to them how dangerous that transaction was, that exchange, right? So mediation resolves disputes. This is about managing that relationship. Now, there's a lot of talk about early dispute resolution. Again, within the concept of early dispute resolution, we're already at a stage where the parties are identifying dispute or dispute about to happen. So if you can see my cursor, I hope you can see my cursor, we're already in trouble with the dispute. Let's say the arrow's the dispute, the mediator comes in here. Even if it's early dispute, we're here. We're taking this all the way upstream at the establishment of the relationship and of maintaining the relationship throughout, getting in there when they hang up the phone with one another. If there are regular check-ins with both sides, those things come out, and you're dealing with them throughout the relationship, not early in the life of a dispute. Okay. Prevention begins at the beginning. It continues throughout. We are preventing those disputes. So we have this is another new concept. It's not new to have things that are new in this field. The beauty of our field is that we get to be creative. We get to come up with new ways of dealing with people and their conflicts and their problems. I want to point out one thing about prevention being new and not new. So when Frank Sander in 1976 gave his paper, The Causes of Dissatisfaction with the Administration of Justice, in that presentation, there was a sentence, only a sentence, but back in 1976, a throwaway line was, there needs to be more focus on prevention. I think that's kind of cool. That's just an aside, so it's sort of not new. And we have all these other ways. Ombuds is a form of preventing problems, not always, but that's in a different context. That's another application of these skills. It's within an entity, not entity to entity, but that's a way of dealing and diffusing and addressing before things expand. We have guided choice. So I've been speaking about process design in terms of prevention and the flexibility and the bespoke nature. Guided choice is a new approach to when a dispute arises, figuring out, should it be arbitration? Should it be early neutral evaluation? So let's look at everything and not just immediately go to mediation necessarily. We've talked about dispute review boards. Those are well known in the construction field. Dispute review boards in a construction project that needs, where time is of the essence, you can bring in a dispute review board. Often it's adjudicatory. They give an opinion binding or not, so the project continued to move forward. This could be adjudicative, again, bespoke, or facilitative, more interest-based. The difference between adjudicative, it more than likely is going to be rules-based, legal-based, based on the law. Facilitative can be more interest-based. Early neutral evaluation is one approach. Deal facilitation, which is using a neutral with this enhanced set of negotiation skills to help parties in a complex cross-border multi-party deal put their deal together. And then prevention, why not? So what's happening? What is happening is, as I've spoken about the CPR protocols, CPR model rules, we also have, they have a pledge. And there are a number of corporations, especially those who are active in CPR, who recognize the value of this. And it's starting to catch on with this self-selecting group. Members of CPR tend to be somewhat self-selecting, and having attended their conference year after year, I'm telling you who have not been there, it's taking hold. Schopenhauer said, all things are, first they're rejected, then they're ridiculed, and finally they're accepted as being self-evident. We're moving to the accepted, where they're talking about it as being self-evident. And I heard the Associate General Counsel of Microsoft talk about the focus on prevention. Almost jumped out of my seat. And maintaining relationships as a way of implementing prevention. The General Counsel of Bayer is very much in favor of this. I'm hearing it. And the metrics are pretty cool. Hard to get metrics on litigation that's avoided, but I like the Intel metrics. So where are we going? Well, we know that affiliation managers exist in the pharmaceutical space. UNCITRAL has a program. They have draft guidelines in the investor state area. And the topic is prevention. You can go online, see their draft. They're focused on prevention. The ICC has a report and has been exploring prevention. I would say the report that they issued is more early dispute resolution and alternative ways of resolving dispute as opposed to preventing them. But still, it's the concept of prevention. I spoke to you about the Intel Standing Neutral program, and I'm hearing, again, self-selected group, but it's beginning to take hold. So to me, and I'm old, Jeff gave me credit for 30 years doing this. I don't get to do 30 years without being old, but having lived through seeing mediation gain acceptance, we know the path that it took through that acceptance. It didn't happen in 1976. There are still some areas where it hasn't happened in the international space, for example. It's still something they're talking about, they're resisting, they are not there yet. So it takes time, and you need champions and you need metrics. And if Microsoft or Bayer, Airbus in Paris is very much in favor of this, Carl Hennessy is a champion of this concept, we can see this take hold and happen. So that's where we are. And this may be a short presentation, but I hope you have some questions. But that's because if you speak to businesses, they're not in the business of litigating. The former CEO, Carlos Hernandez, CEO of Fluor Corporation, said, and I've heard others say the same thing, we are not in the business of litigating. They want more business purpose and less litigation. So thank you all for letting me come and talk to you. I'm pretty excited about this. I think it's really important. I think we are changing a paradigm, and but I'm happy to share this with you. Now I'm going to see, are there any more questions? Are there any questions? However anybody wants to,
Joan,
I'm going to go through.
This terrific, Joan. Thank you. Very stimulating, a lot to think about. Let me ask you a couple of questions, and then we'll open it up to others. First question, if this is such a great idea, why aren't people doing it already?
That is such a great question. Why did it take so long for mediation to get established? So let me give you some of the reasons I think it took so long for mediation to take hold. I think anytime you try to change a paradigm, it's hard. And Daniel Kahneman, who just passed away yesterday, so sad to hear that, status quo bias. I think also it threatens people. I think the gatekeepers are litigators. And we know when mediation first came on the scene, there was resistance. They would say it takes longer, it's just another step, it's going to delay things, it's going to cost more. What do we need it for? We're settling lawsuits by ourselves. What do we need it for? Right? Anybody besides me remember that? Same thing. What do we need it for? Is it going to cost more and it's going to delay things? And another more unspoken, but we know and we suspect that I think some lawyers fear that they lose, they're not going to be as important. How are they going to put their kids through college if there's no litigation? Is somebody else going to get between me and my client? I mean, I think there has to be some of that. I appreciate your nodding, Jeff. You agree with that, right?
Well, those concerns are there, and somehow mediation broke through sufficiently that a bunch of us can make a living doing it.
Yeah.
What do you think it would take? Some kind of internal champion or some high-profile situation? How do you make a headline with a dispute that never happened?
Well, first, can I say I agree with you? Ultimately, it broke through. And what? It only took about 50 years.
So I assume you have some thoughts in mind as to
For how to get it to take hold.
accelerate the process with respect to the dispute prevention protocols you're discussing.
So first of all, when companies, first of all, it's harder to understand. I mean, we know from empirical studies, we know from research that once you know something, you can't remember when you didn't know it.
Mm-hmm.
But this concept is a little challenging for people to understand initially. So a lot of times when I talk to people, I will find out what they think I'm talking about is early dispute resolution.
Mm-hmm.
And it's really hard for me to get through to people who immediately start answering and talking about the dispute, the dispute, the dispute. So the first thing is getting this concept through. When you get the concept through, and especially to the users, it has appeal. There may be some will it work, but the way things get accepted, and another way in which we finally got over that resistance with mediation was top down. So the courts started requiring it. Clients started wanting it. The government in 1998, Clinton issued an executive order. The government started implementing it. So I think corporations, I think clients are the corporations, and corporations do not want all this litigation. The former general counsel of Bayer and Scott Partridge, I heard him say to a group of lawyers, if you don't do it, we'll find someone else who does. That's helps. I think that sort of messaging will help. So that's one way of getting it to happen, top down.
Yes, and Scott was our guest here on the New Possibilities Hour just a couple of months ago. He gave an excellent presentation, and I encourage people to look up the video of that on the willworkforfood.news website or on my YouTube page. So, Joan, is there a way for neutrals, for people who might be qualified and interested in doing this kind of work, is there a way for us to help promote it that does not look like self-aggrandizement and just like we're out there trying to hustle up some work for ourselves?
Well, what's wrong? I mean, if it ultimately helps you, that's okay. I mean, I think the purpose is, for me, I mean, I think the people most likely to do this will have knowledge of the specific industry. I think a pharmaceutical company will probably pick someone with institutional expertise in pharmaceuticals, understands that's probably where the market will go. But I think high tides raise all ships, and the market will decide. But I think the more this is known, I think the better, the less out there it sounds, which is what I'm hearing at some of these conferences. So I want everybody to spread the word.
Mm-hmm. So in the construction field, where the DRBs have achieved some popularity, uh, what can we learn from that experience that would allow some cross-pollination into other industries?
Well, first of all, sometimes I think this, lawyers are notoriously risk averse. So does it strike you as somewhat remarkable that DRBs are only used in the construction industry?
Yeah, it does.
So that's the first step, is DRBs do not need to be limited to construction. That's a process that could be used in a joint venture. Let's take the DRB example and let's add to DRBs. DRBs are not necessarily, but often are adjudicative. What if a more facilitative approach were added? I mean, DRBs could be an individual, could be a group of 3, but in some way adding a facilitative element
Mm-hmm.
would maybe be a way to get us there.
So if we want to talk to people about these sorts of processes and mechanisms, and we're at a cocktail party and we want to be just sparkling conversationalists, is there a specific example or case study to which we could point and say, here's a place where these folks actually used it and it worked spectacularly for them?
Well, Scott's example, there's two that come to mind immediately. Scott spoke about how he worked with his competitors
Mm-hmm.
and facilitated communication. That totally illustrates the importance of the relationship and communication, and not attributing bad motives, and to maintaining trust. So that's an example that worked spectacularly. The other example that works spectacularly is the Intel program is a standing neutral program. 18 billion, does that surprise you from construction? 18 billion with a million, one small case? That's unheard of. They also speak about something called the Hawthorne effect. I've read both sides of whether it does or does not work, which is to say that having that mechanism in place, like a DRB or a standing neutral, has a psychological impact that causes parties to not get into trouble in the first place, knowing that that individual is there to either impose or to be brought in encourages their ability to work it out between them without having to resort to that third party. So those two examples, I would say, I think 18 billion is pretty good. It's hard to get metrics on how much litigation is avoided. Because it never happened. So how do you get a number on what never happened? I also think the example from the pharmaceutical industry is great because you don't necessarily need a neutral, right? You can have this system where there are people designated as maintaining the relationship to deal with it. So if you can have a protocol where problems go to them and they can help maintain communication and they have a relationship and trust.
So with Scott Partridge's example, as you mentioned, it was Scott, by dint of his own skills and personality, who was able to accomplish these things. He didn't go out and look for a third-party neutral to help him facilitate those relationships, as I recall. So let's say maybe somebody listening to this webinar thinks, well, this is interesting stuff. I'd like to do some of this. How would somebody go about trying to get some business going doing this kind of work?
So this is the chicken and the egg problem. The consummate chicken and the egg problem. To be able to do this sort of work, so we all know all sorts of different styles of mediation, and parties should be free to choose whatever style of mediator they like. There are those mediators, some retired judges, absolutely amazing, fabulous, wonderful, effective, who are early neutral evaluators, decide at 10 a.m. There's one I know of in particular, listens to both sides, tells them where it should settle, 10 a.m., you don't want it, okay, goodbye, I'm done. At the other end of the spectrum is the mediator who uses the full set of skills. Doesn't have to, it can be in a commercial context. There are some really amazing mediators who come to mind, some on this call, Jeff, and who can use the full set of skills to do what's needed in a situation. This particular process needs that skill set. So to prepare yourself, you need to go get that skill set, practice those skills. Those of us who do it know it's harder than it looks. I can tell you what reframing is. Can you do it so you don't annoy the heck out of somebody? Can you pick up on when someone is high context speaking? Can you get that? Not only because of the country they come from, but because of their particular cultural makeup. Can you pick up on these sorts of things? Can you manage different negotiation styles? Do you have that full, sophisticated skill set? That's on the one hand. On the other hand, yes, at the moment, there's not a lot of business for this line of work. So we need to have people ready to do it. And then we have to build the marketplace. But I'm optimistic. I'm optimistic for the same reason I'm optimistic in a mediation is it's in everybody's interest.
Okay, let's open it up to our audience. I'm sure people have questions. We have quite a manageable size crowd here. If people have questions, why don't you just unmute yourself and let's keep the conversation going.
Hi, Karen. Nice to see you. Hi, Doug.
Oh, Joan's going to start.
Hi, good to see you.
Joan's going to start calling on people.
Cold calling.
She's a law professor. She knows how to do it. So if nobody volunteers questions, she's going to call on people.
Sure, Jeff. I'll go ahead and volunteer. And thank you, Joan, for this excellent presentation. Um, I've spent a lot of time thinking about this concept as well. I'm a big fan of Lisa Amsler's work on dispute system design. So my question is, what's the sell to businesses that feel that they can trust their own team to manage disputes, right? A supply chain company, for example, they have account managers. They're responsible for managing the relationship with their clients. So if there's a dispute, oh, our team has it, it's perfectly fine. Why do we need a neutral? That's just a cost operation.
Right. So, how are they compensated is one thing. Are we incentivizing them to work on relationships? Are we training them to recognize problems in the relationship? Are we training them in the defense contracting area? Wolf Krumholtz, I think his name is, was doing training with, I think it was General Dynamics, I may have the wrong company, in giving them this skill set. So I'm also a fan of Lisa's and system design, and this is a place for it. And can I tell you, I appreciated your nodding throughout. That was great. I got great feedback from you. Thank you. I so appreciate that. Hey, Karen.
I apologize for the mask. I have someone here with me today, so I have to stay masked today. Are there training programs within existing ADR educational programs, University of Florida or elsewhere that you know of, in these special cultural awareness skills and other specialized skills that are important in order to be effective in building relationships and not just resolving disputes?
Mediation 2.0, not just 1.0.
Correct.
So I have been working on a training program with Andrea Schneider, now of Cardozo, formerly of Marquette, on a training program through CPR. So it's taking, so not yet, probably. There's a textbook in the works that's going to be published from the ABA business law section on prevention. So not yet. This is at a higher level, and yeah, not yet. But it's coming.
For those of you not in the New York area, Cardozo Law School is part of Yeshiva University in New York City.
Yeah. And there's not a law school curriculum yet, but it's coming. And I am including discussion of it. I'm going to bring a speaker to my law school about it. And starting. You're on the forefront, everyone.
So Joan, let's say you're lucky enough to get hired. You're at the cocktail party, you're talking to the general counsel of Megacorp, and the general counsel says, "What a great idea. We want to bring you on board and help us prevent disputes 7 days a week." So let's say then you're presented to a counterparty in a contract, and the counterparty says, "Wants you to meet Joan. She's our standing neutral. She helps us resolve all disputes." Would a counterparty be, well, how do you prevent a counterparty from saying, well, you're paying this person and they work for you full time and you expect them to be a neutral facilitator of resolutions? How does that work?
So in the Intel program, they do impose on the people who work for them this program. But ideally, in my hypothetical, those two joint venturers, at the time they entered into their contract, although they could do it at any point, but at the time they entered into their joint venture, or perhaps even the neutral could have helped them put together the joint venture, they need to systems design, right, Alec? But they need to set, they should both be selecting. It's the same way you would hire any neutral. It should be someone that they both select, if they can, that they both pay for, who has loyalty not to one side or the other, but to the relationship, to maintaining the relationship. That's how you instill trust. And this neutral should, at the beginning, in consultation with the parties, talk about what this process should look like, how they should be kept in this relationship. Should they be attending regular meetings? What would be the triggers for them to be brought in? How would they be compensated? And what are the expectations? What are the processes going forward? And again, these things could be modified as things progress, but there should be expectations set initially. And it should be both sides. And even though Intel did impose, the neutrals were neutral. That was a condition. The neutrals did not have loyalty to Intel over the contractors. They
Okay.
were neutral.
Natalie has suggested that I call on the great David Armstrong.
Oh my gosh.
A lot of time. So David, last question or point to make is yours.
Well, Joan, great presentation. I am an active standing neutral, and I'm on 7 different boards right now, and they are DRBs. They're dispute review boards. And those of us in the industry that do these for a living really don't like the idea that they're called dispute review boards. They should be called issue review boards, because as you stipulated, most DRBs we don't evaluate the situation from a legal basis. It's an interest base. And I do construction DRBs, and we attend monthly meetings or however we want to set it up with the 2 parties so that we're active. We're there on a monthly basis. We're there on a quarterly basis at the least. And we basically become recipient witnesses to the construction process. We're there. And we want to address everything when the issue comes up. And you know that to get to a dispute, first there's an issue, then there's a conflict, and then people take positions. And that's the wrong time for standing neutrals to come in, because you're basically asked to arbitrate the case. You weren't there, you don't know all of the reasons. All you can do is base your opinions or your recommendation on what you hear at the review or the hearing. So, boy, what you're working on, Joan, is so important to business. I've been a business entrepreneur all my life. The last thing I want to do is have litigation. That's what intrigued me when I thought about retiring from the construction and development industry. Went to Pepperdine School of Law and studied alternatives to litigation. And from there, I found the Dispute Review Board, and I was educated in that. They have a process where they have, for the state of Idaho, there's 20 of us that do all of the dispute review boards. The 2 parties select us from based on our backgrounds or our experience. We always have to disclose whether it's a limited number of contractors, and it's the Idaho Department of Transportation. So you have to disclose any conflicts of interest. And it's been a great process. As far as I know, for metrics, and I also do them for the state of Washington, those 2 states, Washington continues to have a few litigations a year, and those are billion-dollar projects in Seattle area. In Idaho, we do get up to $1 billion projects, but I don't know of any litigation whatsoever since the DRBs have been implemented in 2008. Now you could check that, but that's a metrics that you just can't afford it. You have a limited number of contractors that can provide the service, and you have a single owner. So I really appreciate you trying to expand the knowledge of these acting as standing neutrals. I think that I totally agree with you that for attorneys, especially that want to get into this, they've probably specialized in something in their career. If it's construction law, it's easy for you to step in and get on these dispute review boards in construction cases. If you've worked with large corporations, that's perfect for you, or political or whatever, but you should have some knowledge more than just your mediation skills. But I'll suggest if you do apply for some of these, you try to put them together. Don't come in as an attorney. Don't come in as a contractor. Don't come in as a scientist, medical scientist. Come in as a mediator, someone that wants to work with these two parties on their interest base and not on resolving a dispute. Don't let it get to a dispute. Prevent the dispute.
How perfect. David, I'd love to continue this conversation and collect your metrics. This is wonderful. Thank you so much.
You bet.
Yes, and Joan, thank you so much. I know I speak on behalf of Natalie and Jean, even though she's not here. This was a wonderful presentation. We encourage people, if they're in a position to contribute, please consider contributing to foodforkidsfl.org. That's FOOD, the numeral 4, KIDSFL.org, in honor of the wonderful presentation that Joan Stearns Johnsen made for us today. Thank you so much, everyone. Great presentation. And with that, we are complete.
Thanks. Thank you so much, Jeff and Natalie. Thanks, everyone.
Yeah. Thanks,
Pleasure.
Jeff. Thanks.